So when Joanne and I were talking about the presentation for today, I came up with this title, and if you look at it and you pay attention, as Joanne astutely did, she said, you know, it sounds great, but it doesn't fit, it's a mixed metaphor. And I said, that's perfect for IP. Because in IP, you're dealing with the law and the science, and they don't always mix. And although the law is trying to move a little faster, it's never catching up to the science. If you paid attention to the Senate hearings last summer, you saw the wonderful senators asking the executives from one smartphone company about their competitor's product because they just didn't understand the difference. That's pervasive throughout the IP law. Now, if you've ever worked with a lawyer, you know that we like to rely on precedent and people who are smarter than us and have done things before us. So I thought, fitting today, who are the smartest people that we know? And that's the Jedi, right? So I'm going to start with a quote from Luke Skywalker. It's not going to go the way you think. When you're dealing with IP, you're dealing with an imperfect set of knowledge. You don't know what your competitors are doing. You don't really know how the government's going to react. And even if you knew everything that's out there right now, there's by design an 18-month window of secrecy. So you have to play the game with as much knowledge as you have, knowing it's not perfect. Now, why do you care? Because as Mark Getty of Getty Images said, and I'm going to go through just a bunch of familiar quotes to kind of guide our discussion to make it a little more interesting and appealing. Intellectual property, it's the oil of the 21st century. That's the value of your company. That's most of the value that you have. And we're talking about your patents, your copyrights, your trade secrets, less your trademarks in this industry. And why do we care? Because the investors care, and that's where the money comes from. And they like to see the assets. Those assets can be traded, they can be sold, they can be licensed, they can be mortgaged. The trouble is, as you go down this road and you're hungry for the money, which you will need if you're starting the company, you need to avoid the problem that was in the producers. If you saw the producers any time you saw that they took in all this money and the only way they could succeed was by failing. So the wonderful quote, we got the wrong play, the wrong director, the wrong cast, where'd we go right? You don't want to fail because you succeed. So you need to be careful as how you take in those early dollars, who you take them from, and what you give away. Next moves on a great quote from Agatha Christie. I don't think it's necessity is the mother of the invention. Invention, in my opinion, arises directly from idleness, possibly also from laziness, to save oneself trouble. And it's a little tongue-in-cheek, but it's a good point. It doesn't matter how you get to the IP asset. If you take 10 years and your neighbor gets it by staring, and she gets it first, she wins, okay? Next, the slide got shifted a little. That's Justice Kagan if you're not a court follower. And about 6 years ago, we were dealing with the issue of gene patents. Remember, someone had the patent to the BRCA1 cancer gene. And the court, as all the justices are, don't really like patents. They don't like intellectual property in general. And she sat on the court and she said, you know, the PTO is a little happy giving out too many patents. So you need to know in today's environment, the courts are a little resistant to upholding patents. That said, 5,000 patents are litigated a year, 300,000 are issued each year. The Patent Office, which is, I like to tell people, and I've heard this from one of the examiners, it's the Patent Office, it's not the No Patent Office. They're in the business of giving out patents. And because the investors care, you need to play the game to get to the Patent Office. That means you need to pay attention to whether your inventions are novel and not obvious. The main areas that are trouble for the biotech industry today are those naturally occurring products, those molecules that are found in nature. If you are as old as I am, you remember the 80s, there was a boon of molecules coming out of the Amazon. And big companies were sifting through them, and then they go to the patent office, and they get a patent to an isolated molecule, and they get nice rights for 20 years, and everybody's all happy on their end, not on the client end necessarily. But the 2013, the court says, no, that's not good anymore. Those are no longer patentable, those isolated molecules. So you need a new strategy going forward as to how you're going to get protection and get the investments. The other area is if you're in the bioinformatics space or you're doing algorithms or data processing, there's been a lot of resistance to allowing those patents to stand. If you read the New York Times, they call them the methods of doing business, and they talk about the evil patent trolls. But they're all part of the same idea that they're kind of abstract. Again, the courts aren't really upholding them, but the Patent Office is trying to push back, so you need to keep pushing forward. The other thing to remember, if you have kids, you've been to Disney, you've been to It's a Small World. The US market, given what's happening, is no longer such a big market compared to the world that you can ignore it. So your strategies have to be more global. You have to start thinking about Europe and getting the dollars, the euros, to invest there for your IP rights. And the standards are very different around the world now. You know, as the US starts to restrict things, other countries, for example, Australia is great. They give you anything. It's nice, it's broad. We love the Australians. Europe's somewhere in the middle, but there are different tensions, and you have to play the three-dimensional chess game. Next, from Mark Twain. Only one thing is impossible for God, to find any sense in any copyright law on the planet. And this was written in 1902, so 115 years ago. This is my presentation for Michael, because he's laughing at every quote. And he was having a problem, particularly actually with the Canadian copyright law at the time. But right now, computer code is actually copyrightable. So you do get copyright rights in your code, in the original creation. The problem is, how far does that extend? Is it just the literal code? Is it how you organize the modules? Is it the big theme that's happening in the big overall hierarchy? And where along the spectrum is that going to happen? If you've been watching Google and Oracle saga, they're petitioning the Supreme Court to try and redo or reset what happens in copyright law for code. How broad are your rights when you have the right? Again, the Supreme Court doesn't really like intellectual property so much, but they like copyright more than they like patents, so they uphold them a little more. One of the issues is how much of the code could Google take from Oracle or from their predecessor Sun and still use it in their phones and in the APIs that they were going to do. The other issue is, what does it mean to be a fair use of copyright? And I was speaking with one of the deans just beforehand about this, how he had this issue come a few years ago. You may have heard of fair use. Am I going too fast? Go ahead. In copyright. It's the idea that you can take things, and if you use them for a different purpose, it's okay, it's no longer infringement. The problem is everybody gets that wrong. Everybody thinks that it's just a little use is okay use, which brings me to Inigo Montoya. You keep using that word. I don't think it means what you think it means. Exactly, inconceivable. That's for fair use. So if you were on the internet and you wanted to create something, for example, and you decide to take a picture from the internet, that's not necessarily fair use. If you transform it for an education purpose, there are limited times where it is okay. But just because you take a little from the internet, particularly my friends who are in the computer code industry, that's not okay if you're using it in your business. It's not a I will not get caught use. It's a fair use for a different purpose. The other issue is open source. As you're doing the algorithms and your programs and you're thinking about your code, a lot of you will use open source. Open source is fine to use if you comply with it, all the rules, because if you don't, it turns into a copyright violation. And if you're using open source for your business, you need to log that because, again, the investors care. So when I vet a company for the hedge fund people or the investors or the angels, they want a list of every time you've used open source because they want to know where you get your code from to know it's yours so they don't commercialize the product and then have liability. Last step is, as you're working with your companies, setting them up, investing, counseling them, a few boundaries to set. The first is a quote from Robert Frost: good fences make good neighbors. It's the idea you need everything contracted over, particularly the first founders or the early people in your company, so you know who has what. There's a wonderful question earlier on today about this. People want a piece of the company. If you're coming out of academia, you need to be very careful because every institution has a different set of rules, and the rules are getting more aggressive by the institutions as to what their professors and sometimes graduate students can do. If you use their computers or their labs, they may own it, depending on the policy and what you've agreed to. You need to be careful, and those policies are being changed frequently now because the universities know they can get a lot of revenue if they control the IP. The next issue is to follow the money. When you start licensing and doing the deals that we're talking about, the one thing to figure out is who's paying for what and who's getting the money. Usually the IP should track that, the ownership of it, the control of it, but you need to look at those two things in parallel. You can draw a line on your sheet. Where's the money coming from going? Where's the IP coming from and going? Pay attention to those two things. If they don't match up, you're giving away too much, or you're not getting enough. And the last thing I want to talk about is the loose lips sink ships motto. I am all for collaboration. I started a little bit in the science world, sequencing DNA. It's important for scientists to share, and I get that. The challenge is if you share too early or share too much, you can lose all your patent rights or your trade secret rights, and that can kill the company. So you want to be careful. The first thing before you share is, should I have gone to the patent office first? Is it okay?